This morning we continue our journey through some of the remarkable responsa of the past generations, and we're going to look at it's business, not personal. I hope everyone appreciated the little image, the Godfather, and the idea that, especially with regards to the modern corporation, for the most part, in Judaism, has a lot to say about finance, about the economy, about agriculture. Has not as much to say about finance, except when it comes to if there is going to be a loan between one person and another. Source number one: Lo tashich liachicha neshech kesef neshech ochel neshech kol davar asher yishach. You can't charge interest, and it's not just financial. It's not just I'll lend you 100 if you pay me 110. It's also the ability to get preferential treatment. It can't be ochel. It can't be food. You can't lend someone $100 and then they'll be nice and hey, have this cup of coffee, or cut the line. Things of that sort. It's behavioral. It's not only financial. And then very famously, la nachri tashich. You can charge interest to a non-Jew. Ulachicha lo tashich, but not to your brother, not to your fellow Jew. L'man yivarecha Hashem Elokecha b'chol mishach yadecha al asher telashama b'rishta. So you'll be blessed on the land that God has given you. So of course, this is where we have Jews are money lenders, right? This is we're very useful because say whatever else the Christians gave up about the Bible, they didn't give up the interest. So they didn't charge interest to each other. They let the Jews charge interest to them, and this has led to all sorts of trouble between us and them. But this was the idea that you can never charge on interest. You have to, almost the idea we're familiar these days with the idea of a gamach, a free loan. All Jewish loans are supposed to be free. There's never supposed to be the interest, and so there's that challenge of how to charge. The idea of in order to lend, you have to be willing to lend interest free, and it's not just the borrower and the lender, or it's not just the lender, it's also the borrower. A borrower is not allowed to borrow on interest. And as the Mishnah above Mitzvah source 2 describes, it is really a whole bunch of people. And these people violate the prohibition of interest, of ribis, the lender and the borrower and the guarantor and the witnesses. And the rabbis say also the scribe who writes the promissory notes violates this prohibition. These parties to the transaction violate different prohibitions. And it's about interest, and it's about taking interest and giving interest and being the creditor, or even lifnei iver lo titein michshol. Right? I say, if you don't mind, please write up this loan arrangement that we're going to have. You wrote it up, and the arrangement we have as interest, you're guilty because you were participating. You're kind of an accessory before the fact, after the fact. There's that level of expansion of the of those who are involved, who get caught up in this type of an arrangement. And so we know that with regards to charging interest, we see it as it's a very serious offense. It expands to include others. We're definitely, the idea is to discourage this at all costs, in addition to which the idea that the reward is pretty great. We always talk about how there are very few places that the Torah rewards the performance of a mitzvah. Very famously, long life for honoring our parents, and shiluach hakan, sending away the bird to get the eggs. Here it says, hey, you should not charge interest so that God will bless you. It's kind of, the Torah doesn't take lightly this idea of promising reward, and here it does, because it seems this very serious offense, very important rule governing society. At the same time, right, what kind of motivation do I have to make a loan if I'm not able to get a little bit back? I could use the Godfather language, wet your beak a little bit, right? After all, we're not communists. But the challenge is, so it's a mitzvah. And so remember, part of this is there's the mitzvah of tzedakah, right? And sometimes, we have to keep in mind the layered structure of the way that we're supposed to help other people. Someone's in need, you give. It's not about loan. If someone's in need, right, you facilitate them getting a job so that they can provide themselves. It's not always this idea of a loan. There's responsibility that kind of supersedes the lending, and so there's a certain element of of generosity that is meant to be engendered within people giving, that the loaning without interest should be second nature. If you're willing to give, if you're willing to facilitate, then of course you're willing to loan, because a loan is a commitment to repay. And not only is there a commitment to repay, you see that from the examples that people mentioned in the mission, there's a guarantor. So lending isn't necessarily giving without getting back. You're just not going to get back more. So there's a certain philanthropic culture that's being produced, and the idea of lending is on some level a little bit more empowering to the person in need, that they're going to give back. You're just not going to make it more onerous for making them give back more. Right? The whole idea of arev, of a guarantor, that's where we get the idea of Kol Yisrael arevim zeh b'zeh. It's not just that we're responsible, we're a people, we're actually obligated. I still very clearly remember the way Rabbi Aaron Soloveitchik explained it. The idea of arevim, just like the guarantor has to repay the lender when the borrower doesn't, if someone isn't performing a mitzvah, that's my problem. They're not saying Kiddush, that's my problem. They're not keeping Shabbat, that's my problem. There's a real guarantee that's being provided here. So it shouldn't be so hard to lend without interest, because if we're in a loan situation in the first place, that we've moved beyond the altruism of giving or the facilitation of getting a job, the lending is meant to be a middle road. You have to part with the money for now, but you're gonna get it back. And so that's meant to mitigate any concern we have with regard to interest. At the same time, interest seems, the fact that the Torah makes such a big deal that you can't do it, and the fact you can do it to the non-Jew. And we saw this a couple of weeks ago with regard to even maybe the non-observant Jew. We talked about who's part of the community. Some of the halachos about the community has to do with the fact that if someone doesn't keep mitzvahs, you might be able to charge them interest. We saw that was rejected. But the very idea that interest, if you talk about something so much, then the likelihood is, yeah, that sounds like a good idea. But I can't do it. I could do it. I might be able to do it. I can't do it. It's in the air. And then the Jews, so much so got into the quote unquote money lending business. It became something that became more relevant and discussed within the Jewish community, what happens with loans. So, right. So Hirsch is mentioning the idea there's the heteris. There's the permission to do business. So what is generally done is that loans are not looked upon as loans. If I loan you $100, I don't say you're going to pay me back 110. I say I'm loaning you $100, and I'm making an investment in you and your future endeavors, and my investment in you is going to yield a $10 profit, a guaranteed $10 profit, right? So in the same way that interest in a bank, you get the money, so the same thing, but it's not interest. It's an investment. And so this was something that we see meant to mitigate against anyone's thinking they don't want to charge interest-free, loan interest-free. It kind of mirrors a little bit the idea of the Pruzbul. The Pruzbul was instituted, right? The idea that the Shemitah year, the sabbatical year, cancels all loans. So leaving aside interest for a minute, if I lend $100 and you're guaranteeing, you agree to pay it back, there's a guarantor to pay it back, and everything's all in place, the Shemitah year comes, wiped out. I'm not going to get it back. So if I have a loan that's not going to be repaid until the Shemitah year, there's a certain disincentive there for me to make the loan in the first place. So this was something Gemara Gittin talks about. The Hillel noticed, right? People weren't lending, and so therefore they introduced Pruzbul. Pruzbul was a mechanism that I'm loaning you $100, and before Shemitah, that loan is not a private loan; it's a communal financial obligation in the hands of Beit Din. So you're not, the $100 you owe me is not that you owe me $100 in repayment; you owe me the return on the communal investment. Pruzbul, it sounds a little bit like a workaround. It is a workaround. But the idea is it's a workaround that fits within the system. Great book by Rabbi Daniel Feldman from Yeshiva University, all about different halachic workarounds, Pruzbul, selling chametz, a whole bunch of others. The idea, though, was to ensure that the culture of giving and support continue. So you have that workaround with the loans in the Shemitah year. So then the idea of a workaround to loans in general emerged, and that was the heteris. So the Torah Tamima, Rabbi Baruch Halevi Epstein, in source number 3, the Sukkim and Vayikra is also talking about loans. He said, you're not allowed to charge interest. So he wants to know, like, okay, you're not allowed to charge interest, but everyone charges interest because they just do the heteriska. So hine davar yaduahu. Source Tarisha bedoros ha'achronim himtziu heter halva beribis beheter iska shnevarin yena b'sama. We have this permission that we make it into a business deal as opposed to it being a loan. L'chorah davar pelahu. Shalom atzinu kol remes kal b'tar lahamtes heter lisazeh. Where do we see an allusion? Where do we see any hint that we're able to be lenient and permit this? Where do we see any type of indication that there's a rationale? Think about it. In the Prus Bowl, there's a rationale. No one's lending in the sixth year anymore. Hillel realized this, so he found a mechanism to facilitate more lending, more giving, more support. What is this? This is not the same thing. Where do we see any indication that it's helpful? So v'nira b'zeh shero chachamenu yisod v'gam hechrech leheter inyan zeh bichlal. Mishum dechaku uvo atchunas ha'isra zeh b'yisodo v'ikaro shebetorah habanoi misor ha'ir v'chai achicha imach. Really, the rabbis looked at the situation of lending and not charging interest. It's all part of the responsibility of the chei achicha imach. Your brother should live with you. You should facilitate it. Everyone has what they need. What were they? How did people live with each other back then in the times of the Torah? Avodas adama, agriculture. That was the key. You planted, you grew, you harvested, you ate, you sold the extra. It was an agrarian society. If you grew more wheat than you needed, you were rich. It wasn't about the financial. It wasn't about the monetary, right? It's this kind of Keynesian and all the capitalist discussions. Right? That all came later. The money that transferred hands when I need to loan you some money, you want to lend me some money. That wasn't about wealth, wasn't about investment. So I was short. I was supposed to get 100 pounds of wheat. I only was able to harvest 98. I'm short. How can I get more wheat? You got 102. You have more money. So it was all about leveling the playing field, and it wasn't about the money. It was about the livelihood. There was no even a thought of, oh, I'm giving you 100, you're going to give me 102. There was no conception. They didn't even think about things in those terms back then. Because it was all about you having a couple extra dollars in your pocket didn't mean anything in this agrarian society. The Middle Ages, the Jews were dispossessed from the land. Right? The Jews were not allowed to own land. So therefore, we became businessmen. Right? Then they had the problem of ribis. Money is now at the center of our business system. It's a monetary system, not an agrarian system. So it sounds like, is the gold standard, is the dollar the main currency? These things have relevance when it's a financial market. And then all of a sudden it becomes relevant, right? Think of, how many points? What are the interest rates? This becomes a big deal in a monetary system. And now all of a sudden it becomes more relevant, because if I'm loaning to you, if I have a little extra, I need a return on that investment, right? And if money is free, then everyone's just going to borrow money, and that's how they're going to accumulate wealth, because they don't have to pay more. There has to be a give and a take, a push and a pull, to keep the system in check. And that's where the rabbis had to start thinking about this. It had never been. That's how the Torah Tamima understands the evolution of the Jewish economy, from farming to losing the land. It was all part of the Jewish experience that led us to become more of a monetary system. And then all of a sudden, interest becomes a big deal. If I can't charge it, or if I don't have to pay it, the whole economy shifts. And if to ensure, to protect the economic system from being violated by halacha, they instituted the heter iska. Sure. The idea that they were noting the trends, and it's interesting how the Torah Tamid talks about the Middle Ages, because I was looking at another topic, maybe for another time. This idea, there's a famous idea within Jewish law that you're not allowed to go shopping for answers from different rabbis, right? You shouldn't, that one. So there's a whole discussion about that, and it's really not found anywhere in the sources. Right? The Torah doesn't say you can't do that. The Gemara doesn't say you can't do that. They talk about maybe certain rabbinical courts not being able to overrule other rabbinical courts and the like. But this idea that if you have a question, but you can't go to him and him and him and him, it seems a little distasteful maybe, but doesn't have a halachic grounding. And some have pointed out that just like in the Jewish, the Sanhedrin was at one time the main authority, so that the rules of who you could ask and the specific authority of various rabbis, whether it be courts or local rabbis, or the idea of minhag hamakom, that if you're in one place, everyone has to follow the same custom. All of that also fell apart towards the Middle Ages, with a more diffused Jewish population, with less centralized authority. And so really, the Middle Ages changed a lot of the way we approach Jewish law, economy. All of that was changed, and it was a very disruptive period. Crusade was a big deal, and certainly subsequently that. So the idea of the heter iska is very much for those in that industry, those who are in business, those who are in banking, those who lend money. The heter iska became almost essential. You have to sign the heter iska. They're heter iska. It's not an uncommon situation, and so much so that. But what did change is that we're no longer going from individuals who have big corporations. And not only do you have big corporations, you have Jews invest in those corporations. Or for example, State of Israel, you have a Jewish-owned bank. So do all the banks in Israel not charge interest? No, they have a heter iska. Okay, Jewish-owned banks is one thing. What about non-Jewish banks that are publicly traded, that have Jewish shareholders? What about my investment in all the other financial mechanisms that exist in that upon which there's an interest rate? Mortgages, there's certainly Jews in the mortgage business, and how does that work? And so this has been something that in general has concerned people, so they fill out a heter iska. Now the heter iska doesn't have to be so specific. It basically says that so-and-so agrees with so-and-so that the funds that are transmitted or transferred, there's a return guaranteed of X, and it leaves it kind of vague, and that ultimately we're able to figure something out if need be. It's almost similar that this what's discussed is more controversial, but the idea of the shtar mechira, if a person has a company that is a manufacturing company that's operating on Shabbos, right? You have also used to be the store's open, can't be open on Shabbos. What about you own a department store, right? Maybe you own Macy's. Macy's can't close on Saturdays. Maybe you could, makes a big statement. But if not, what do you do? So it was done in Europe, and it transferred over to here as well. The idea of a shtar mechira, that I have a non-Jewish partner. What kind of partner? One who's his share of the profits is coming only from what's on Saturday, right? So in theory, you can divide up how much comes in, whatever comes in on Saturday. All of that gross income is going to fund the net profits for the non-Jewish partner. And how exactly does that work? Well, if we really need to, we'll get a good bean counter, and they'll be able to figure it out. But otherwise, we just agree this is how it's going to work out.
The halachic prenup come from this kind of thinking?
The
halachic prenup.
So the idea too. So the question was about the halachic prenuptial agreement, in which there's an agreement made before a wedding that the couple, should anything go wrong, will go to a beit din. And if they separate from husband and wife, there's additional additional requirement for usually the husband to pay. It's the idea of looking ahead, and looking ahead. Sometimes it's not specified, but it could be specified or it could be determined. So there's this idea of setting conditions that we don't know exactly when or where or how, but we can obligate ourselves now on. It's interesting that the halachic prenup, there are those who have recommended kind of stronger halachic prenups that have, taken on more responsibility. Sometimes the opposition among those rabbis who do oppose the idea is that it doesn't seem like it seems more like it's in word only, not in deed. So to say, so there too, straight up people with the shtar mechira, you don't really mean it. So how does it work? So some people oppose it. Rabbi Feinstein is very, only kind of as the last resort. But so it's the same idea that we can kind of obligate ourselves, and it's almost like when in baseball, when they we'll trade for this person for that person, the player to be named later, right? We know we can figure it out, but we don't have to figure it all out now. So same idea. So the idea of the heter iska within the larger financial world, in bigger transactions, not just interpersonal loans, but in terms of corporations. So it reached the head. There was a famous case in 2018 with Agudas HaRabbanim was dealing with Quicken Loans. Source 4, Quicken Loans, a leading mortgage lending institution in the U.S., is halachically under majority Jewish ownership. Upon thorough investigation, prominent leading halachic authorities have issued a psak that any Jew who obtains a loan with interest from Quicken Loans or any of its subsidiaries, Rocket Mortgage, is in danger transgressing the prohibition of ribis d'oraisa, interest. We therefore feel compelled to alert the public to the psak of the Gedolei HaRabbanim, which states unequivocally is forbidden al pi Torah for any Jew to take a mortgage or any form of loan for Quicken Loans or its subsidiaries or any other Jewish-owned lending institution without a valid heter iska. So basically, you have a bank, you have a mortgage lending operation that's basically Jewish, and they're charging interest. They're wrong, and you're wrong if you take it from them. So pretty big deal. Now, the caveat is valid heter iska. The way this story ends is that Quicken Loans immediately got a heter iska. So that put them back into compliance. It's kind of interesting that how simple, it seems to that the heter iska really is a workaround.
But isn't it transaction by transaction? Is a blanket heter iska that they acquire?
Correct.
Oh, really?
Basically, it's almost like it's almost like the way when you sell chametz.
Right.
You have one pruta for each person in the thing.
Right.
So now there are certain things. Now we'll see we'll see in a minute that there are certain aspects of Jewish law that have to be taken into account. Like, for example, there's something called brera. Brera, literally to choose, but can you differentiate? Right? If you have the heter iska for everything, well, does that apply to every one individual? Yesh brera or ein brera, in what situations? So that was the Quicken Loans issue. However, there are those who take a step back and just wonder, is the modern day corporation, does it have direct personal ownership? And in particular, the fact that nowadays it's not just the corporation. It's not just I may have a mom and pop grocery store, but it's very common today. If I want to have a grocery store, Eli Weinstock, don't own the grocery store. I set up a company that owns the grocery store, LLC, limited liability corporation. The idea, which acts as a buffer in between my direct ownership. And so the question that was posed, first, we'll look at Rabbi Feinstein, and then more contemporary times, Rabbi Usher Weiss. How do we look at the modern day corporation? And this is something that was not really addressed in previous generations because people had direct ownership, or the Jewish community didn't have the same opportunity to have that level of financial ownership and the like. And so Rabbi Feinstein's question here is dating to 1960. That's when he was dealing with it. And it really had to do with owning shares. You see in the source number 5, shares, right? It says, make companies. Shows right? This is companies open on Shabbos. Like we referred to earlier, the idea of, it's a manufacturing company and they're producing on Shabbos. People do it. People own companies and Ford Motor Companies, right? But also remember, Moshe is writing in 1960. Like I still remember, when my grandfather got me my first 10 shares of AT&T, you had like a certificate, right? Now everything is mostly held in investment accounts, and so it's actually it was much further removed. Once upon a time, I owned whatever the 0.0000001% of a company is ownership. So that's that was really Moshe's financial conception at the time. She'ein lahachshiv es hakonim shares shu rak mashu mehem miskar she'elem shum dea b'miskar af le'inyan chelkam lebalim. Shlodomi l'shutfus v'mitzas. He says owning shares is owning a small amount of a company. You don't have any control. You're not even. It's not the same thing as a partnership that the Talmud talks about. V'gam ein hakona shares rotzeh lios balim b'miskar. The owner of the stock shares doesn't want to have anything to do with the company. He wants the company to run well. He just wants the profit. He's really only owning a share is, and so Rabbi Feinstein begins to look at it beyond just the ownership piece. When you buy a stock, you own shares, you really don't care about the company. You really just want the profit, or the price or the cost of the profit is the risk of the loss. Based on how much you have done. Right? He said it's more like buying something which isn't created yet. Right? Let's say you're back then it would have been a farm. I want to buy your crop. I mean, I don't own it yet because it's not here yet, but I do have some rights to it. It's only considered ownership mitzad dinei hamedina, the financial laws of the country. President, right? What about the fact that I would always get the announcement of the AT&T shareholders meeting, and do I want to vote by proxy for the new chairman or the president? He says, they don't really mean that. Your shares are not electing the president. They're humoring you on some level. They don't really share that decision-making power with you. They're, that's the game. They control the majority still. These proxy battles don't usually amount to my vote making all of the decision. And therefore, you don't have to think about it's the owners of the companies because you're not connected to them. Let's say there are Jews who are in management positions. This is not considered facilitating, violating the law, like companies open on Shabbos, because it's going to happen anyway. Right? It's almost like we talked about with regards to if someone's going to violate the law without you, you have no control over them. You're not connected. Like it's similar to those who allow, invite people come to shul on Shabbos, even if you don't know how they're going to get there. He said, look, there's plenty of religious people who buy stocks. If you're really going to be a majority shareholder, that what you say goes, then you're going to have an issue with regards to that type of investment in a company.
So not to distract from the path, but does the same thing? Can you use the same concept for suppose you're owning shares in general foods? Or
they talk about the same thing for chametz. They talk about the same thing with chametz. They talk about the same thing owning shares in McDonald's. That's cheeseburgers, right? There's all sorts of ideas, but so you hear of Moshe is talking about that investing in shares, stock shares in a company don't provide you the level of ownership that is decision-making quality, and you may not really be owning anything. He begins, it's like it's a fake. It's it's all in the air. It's osios porchos ba'avir. Everything is in the air. It's a kind of like try to explain. What does it mean to be in finance? See, it's not mamash enough.
So I have to show this to my daughter, whose job is a proxy solicitor. She works with active investors, and that's what she's doing. She's controlling. She's working on board elections and stuff like that.
I never got a call about my shares in AT&T to vote her way. So that's where Rabbi Feinstein has something similar. A source 6, Lovehu Corporation. שגוף האנשים חבר'ה corporation אין חיים כלום ואין על גופם שום חיוב ושיבוד ולא מצוות פרי הסחור כמו שיש למעלה שנאמר בו איסור ריבש אף אם הוא עני ואין לו הוא חייב בדין פירעון החוב מחויב להשיג מוס מדין התורה לפרוע החוב אבל corporation שהם אין חייבים כלום דים שאין כאן לווה כלל אלא הביזנס הוא הלווה. So here Rabbi Feinstein is starting to move from my ability to invest in these corporations where shares it's not a level of ownership. Then he begins to talk about the company in general. Right? They talk about business losses, they don't necessarily talk about personal losses. So he begins to move to this idea of recognizing that the LLC, the corporate entity, especially if that's what's recognized by the laws of the country, that's the ownership, less so the individual, which will impact, for example, a Jewish bank charging interest. Jewish bank, not an individual private ownership, but a Jewish bank that's a corporation, even if it's Jewish controlled bank. That's where he begins to talk about. And it was really Rav Asher Weiss, and so Rav Moshe is 1960. This tshuva of Rav Asher Weiss is 2004. About can a Jew have the control, the majority, controlling shares in an American bank, especially on Jewish customers. Non-Jewish customers, no big deal. Maybe you can get away with not having to worry about non-observant Jewish customers, but certainly observant Jewish customers who borrow from the bank that you want to control, you're in control of those shares. How does that work? So he's going to approach this in a similar fashion as Rabbi Feinstein and say that you don't really have direct ownership, but he approaches it in a couple of different ways. We'll look at some of this. For those not familiar, Rabbi Asher Weiss, born in America, moved to Israel. Tremendous Talmud Chacham who has broad appeal in all the different communities in the Jewish community. They tell a story, that as when he was around 10, 11 years old, there was an encyclopedia salesman who convinced his parents to buy an encyclopedia, which he devoured, and it kind of sparked his intellectual curiosity. So we owe that encyclopedia salesman a great debt of gratitude for helping to feed the intellectual engine of Rav Asher Weiss. So, source number 7. So, can a Jew get the controlling shares of an American bank when it has Jewish borrowers? So he says, limited liability corporation. We have to understand what that is and how that what are the foundations of that. Right? How do we understand who owns it? How do what makes you the owner? One, are you entitled to the profits or the losses? Your ability to make the decisions, right? It's like I'm the boss of my house because my wife let me be the boss of my house, so I'm not really the boss. Same thing. Do you have the ability to transfer the ownership to someone else on your own? So he says, he says in a corporation, publicly traded corporation, you have these three aspects are three different parts, right? Right? The directors, you have the shareholders, you have the board, and you have the actual CEO. The ones who own the shares, they're the ones who absorb the financial, they reap the rewards or pay the price. Dividends. Right? If you're a shareholder, you get dividends. You get if the company is sold to another one, or by another company buys it, you get a financial benefit. The actual operations, this is the CEO. The CEO is not really a shliach, an emissary of the board. He's hired by the board and fired by the board, but the board members themselves can't run the company. They've appointed someone to appoint the company, so even the board of directors is not really in charge. The directors are those who have been given the opportunity to lemanos es hamankal, They're the ones who appoint the director or other senior staff. They kind of are, we could use the term, they're fiduciary, they have fiduciary responsibility. Right, in general, you take, when things go sideways, right? Generally, what happens? Who do you sue? The board, the CEO, and the board. You generally to sue all the shareholders isn't always the case, right? It's the board who represents the shareholders, and they have responsibility for appointing the CEO. But it's really the boss and the board who are the ones who you look to take responsibility. But neither of them is really in their own silo. CEO doesn't exist without the board, and the board can't run a company without the CEO. You have three different, you have this three-headed monster. Director and they don't have personal responsibility, which of course is tested if something goes sideways and you sue them. Right? That's why you have directors' insurance. Because if the board gets sued, they want to make sure they're not going to be out of pocket. So, when he says they have no personal responsibility, what Weiss means is that if something goes sideways, you're not really suing the individual qua his being an individual. You're suing him as being a member of the board. So you have, so there can be financial responsibility, but it's not personal ownership. So Rav Weiss continues, it's a completely separate animal. Right, so he's kind of expanding upon what we saw in the second Shuvah of Rav Moshe. He says, look, this three-headed monster of shareholders, director, and CEO has no precedent in Jewish law. It's almost he's talking like the Torah Tamima did, right? When they were borrowing and lending in the farming times, they had no concept of interest. It was irrelevant. Now, when it becomes relevant, so then the rabbis had to have a way of regulation. Same thing here. They had no the ownership. We have Shnaim Ochazim B'Talis. You have two people fighting over the same talis. It's two people. Or you have someone damages something else. You don't have, self-driving cars. Now, we can use self-driving cars and figure out who programmed them, and there is a whole halakhic conversation. When it comes to this ownership structure, there's no precedent. So he says, we shouldn't overthink the situation and try to create a Jewish ownership structure here. We should rely on Dina D'Malchus Dina. However the government decides it is where the direction we should go. It's interesting. It's an example of halacha recognizes the law of the land as being able to halachically move something, determine something. On a separate matter, government testimony is viewed as halachically binding if the government has no vested interest in the subject. What's the example? So it has to do with laws of aguna. If someone is informed by the government that their relative is dead, then that can go towards determining if the person is actually dead. Because what is the government? The government's not thinking about halachos and aguna and things of the sort. The government's there to provide to perform a governmental legal service. And I was just reading an article yesterday. This came up in the Titanic situation, where there were very few Titanic agunos, because there were either, like in the case of Isidore Strauss, he and his wife both perished, or they recovered a body. In the one case that was dealt with, no one survived the Titanic. In addition to the various other halachic discussions, was the fact that the woman had been informed by a government official, your husband is dead. And if the government says something and it has no reason to lie or no vested interest, then that's viewed as halachically valid. Not always determinant, but valid. So here, the government tells us that this is the ownership structure. We don't have to outsmart the government, so you shouldn't have to worry so much about, interest. Yeah. This is not like a conflict with Torah. This is what Torah says. Now, the Torah is basically telling us when you have this three-headed monster of ownership structure, follow the law of the land. and he talks about Safnos Paneach, that aimed in Ribis Bebenkin, right? There were declarations made by rabbis in the 19th and 20th century that says, this one quoting the Rabbi Yosef Rosen, there's no law, there's no halachos of Ribis at all in banks. Now that's a blanket statement that not everyone agrees with, but he says, what was the motivation to say something like that? What do you mean there's no interest in banks? Because banks are not privately owned, or at least that was the Safnas Paneach's experience. He says that, look, even if you don't want to rely on the government determining what the ownership structure is, like, look at what's going on here. The shareholders can't decide, the directors can't run, the CEO doesn't have a job, everything is interconnected. You should still worry about it. Because we see how seriously it's been taken. That there are those who say there is interest issue halachically in banks, and it is a problem. So basically, Rabbi Weiss is saying a bank, a corporate structure, you follow the law of the land, and it's not linked back directly, even if its majority shareholders are Jews. But okay, get a heter iska. It's not such a big deal. You signed the document. So then he points out that there's another idea here, is that with regards to, there is an opinion that if a non-Jew has a partner, has a share in the money, there's no interest at all. Right? The only problem is the time charging interest is if it's Jewish money being loaned. But if there's a non-Jewish partner, it's almost the idea of the company open on Shabbos. You have a non-Jewish partner, you can keep the business open on Shabbos. You have non-Jewish partner in the money, you can loan the money with interest. He says, this is disputed. Right? So he's pointing out the various approaches. He's like, look, the ownership structure, the corporate ownership structure is not directly related to the Jewish ownership level of participation in it. It's quote unquote, it's a corporate structure, and so therefore there's no interest issue with corporations. Or maybe there's no interest in banks at all. Or if there's a non-Jewish partner, you can charge interest. At the end of the day, have a heter iska, cover all your bases, especially because these other approaches are disputed. It all depends who's the majority shareholder. And so he concludes the last two paragraphs on the left side of the page. And look, some people were lenient about from banks or from non-Jewish partners. So, put it all together that the ownership structure we can categorize as corporate and not individual. So it doesn't matter if the Jew is a controlling shareholder. And it's a bank. And there's some non-Jewish partnership. You should have a heter iska, that document that allows charging it the same way. That's how all the Israeli banks do it. You're still able to have Jewish ownership, even controlling interest and charging interest. On some level, he's disagreeing with the Agudas HaRabbanim, because because the Agudas HaRabbanim, when they went after Quicken Loans and Rocket, that prompted the heter iska to be signed. What about all the loans until that point? And that could be problematic both for the owners of the company and for the borrowers. So Rabbi Weiss's more expansive or lenient interpretation protected those investments or those loans and repayments from having been borrowed or repaid in sin. But we see that it's something that starts off with basically a certain financial law in the Torah that had that was in one perception back then. We see the heter iska was introduced as the financial, the economies shifted, led to the heter iska's utilization, and then when economics progressed even more so with different ownership structures, it led to further questions about investing in a company that violates Shabbos, or investing in a company that violates Ribis. That led to the whole banking system, that led to the whole corporate ownership system, and the like. I would imagine now crypto currency will be next in terms of, how does that actually work? So stay tuned. Maybe by next, huh?
Nobody knows.
Exactly. It's like you have crypto billionaires. Like really, So who knows? Maybe by next year we'll have more to say on that. And happy to take any questions or comments.
So I thought,
Rabbi,
Yeah.
you concentrated a lot on the lender